I'm going to get us started. I'd like to welcome everybody back for the start of our spring semester. I'm Chris Schrader, the Director of the Program in Public Law, and we've got a wonderful speaker and topic to get our informal lunch conversations off to a good start this semester. Sandy Levinson is the holder of a distinguished Centennial Chair at the University of Texas Law School and has been an astute commentator on and analyst of the Constitution throughout his career. In recent years, he's done some important work on the concept of the emergency constitution and on problems of interrogation techniques and torture. And I certainly have benefited from his writing on those topics post 9/11. With this book, Our Undemocratic Constitution, Where the Constitution Goes Wrong and How We the People Can Correct It, Sandy returns to a topic that's been on his mind for at least a couple of decades, and that's to encourage us to take a hard look at the Constitution that we have inherited, is now over 200 years old in its basic structure, and to analyze it in a hard-headed, realistic way, take a look at it to see if it has some warts, and if those can be found, begin a conversation about what to do about them. So he's here to share some of his thinking on that topic with us and discuss some of the contents of the book. He'll talk for maybe 20, 25 minutes, and then we'll look forward to taking your questions. We also have copies of the book outside, and if this conversation or your previous interest in the book has been piqued enough to purchase one, you can also have the added treat of having the author sign it after the event. And so, Lily, we have one announcement before we get started.
The American Constitution Society is sponsoring a smaller group discussion with Professor Levinson today at 4:30 p.m. So if anyone is interested in going that, there's still 3 or 4 spaces available. We are restricting it to American Constitution Society national members, but membership is really easy. It only takes $10. You can do it online, and you get a free water bottle. So email me if you're interested, lily.north@law.duke.edu, 1 L in the middle of Lily. Thanks.
Great. So help me in welcoming Sandy to the podium today.
Thank you. Chris didn't mention that I was an undergraduate here many, many years ago, and I also had the pleasure of serving for some 6 years as a member of the Visitors Committee, which was very enjoyable and very illuminating. There are multiple audiences for this book. I have to say that the primary one is our fellow citizens. This is not intended to be simply an academic book, though obviously I hope that it is read by legal academics and students, but that's not really the primary audience, because the argument is that we really have a significantly defective Constitution. In many ways, I've taken to describing our Constitution as the equivalent of driving a car with slick tires and lousy brakes after 2 drinks. And we say, well, we've always gotten home safely in the past, which I think in fact is false. But there is this feeling that we've always gotten to a safe haven in the past. But I think, as with mutual funds, past performance is not necessarily predictive of what will happen in the future. And I think that the Constitution generates multiple possibilities of going over the cliff, and that it would be far, far better to discuss some of those possibilities and what to do about them before the going over the cliff or the train wreck, or whatever the right metaphor should be, rather than afterward. Now, let me say at the outset, there are good political sciencey reasons to believe that serious constitutional change happens only after train wrecks. That I'm not sure that any countries or states have particularly good records in constitutional reform simply because of rational scrutiny of a constitution that isn't terrible, but you realize does have problems and you want to try to do something about them. Interestingly enough, a lot of American states do have procedures for constitutional conventions, and some of these procedures have in fact been significant and have led to new, and some would think better, constitutions. But still, generally, I take seriously the argument that even if the Constitution is defective for a variety of reasons, dealing with things ranging from a desire to repress the view, a psychological desire to repress the view that a document that is generally so venerated as the Constitution, it might be painful to think that it's really in some ways a clear and present danger. There's also a different problem which derives from one of the most serious failings of the Constitution, which is its functional impossibility of amendment. That Article 5 creates the hardest procedure for constitutional amendment of any currently operating constitution in the world. That title used to be held by the Yugoslav Constitution, which is no longer a player in the Constitution evaluation game. So we are now number one with regard to difficulty of amendment. I would say, in effect, functional impossibility of amending with regard to anything truly significant and or controversial. In my lifetime, there has been arguably one significant amendment. That is the 22nd Amendment, which may be the explanation of why Bill Clinton is not president even as we speak. But none of the other amendments are of any interest to anyone except a constitutional specialist. There is a general view, which I share, that Article 5, by making it so difficult to amend the Constitution, also stifles discussion. Because cognitive dissonance theory would predict putting the veneration aspect of the Constitution to one side. If you can't do anything about it, there are all sorts of incentives to think that it's, well, pretty good, because it would really be quite awful to think that we are trapped in an iron cage that we can't get out of. And indeed, the original working title of this book was going to be The Iron Cage of the United States Constitution. One of the reasons I changed the title is that as I wrote it and convinced myself of my own argument, that is, that the Constitution really is in significant ways defective, I was no longer satisfied with what I call the trope of futility, which is what you find, for example, in the very, very fine book by Robert Dahl called Do We Have a Democratic Constitution? The answer is no. At the end of the book, though, he says, well, you know, there's really not much we can do about it. And I'm not original in arguing that we have a defective Constitution. What may be different about the book is the rather audacious proposition that there is something we can do about it. That is calling a new convention. Which Article 5 allows. Let me say that most people, including friends and family, get off the bus at the suggestion that we need a new constitutional convention. And I anticipate answering some of the questions with regard to that possibility during the discussion period, and I won't dwell on that right now. Let me dwell on what I think are the most serious defects. Let's begin with the Senate. Even if you believe that bicameralism is desirable, which I generally do, I'm not a fan of a one-house parliament. Nonetheless, would anyone defend Wyoming having the same number of votes as California, Vermont having the same number of votes as Texas, and so on and so forth? For me, this is a rhetorical question. If one believes in any semblance of one person, one vote, one cannot possibly defend the current distribution of power in the United States Senate. There is an explanation for this with regard to the deal that was made in 1787 in order to get the Constitution up and running in the first place. But the fact that there's an historical explanation doesn't justify our continued being trapped in this cage some 220 years later. I have thought since writing the book, and I wish I had the wit to think of it while I was writing it, of the deal that was made in 1945 with regard to the Security Council veto of the United Nations. One can readily explain why in 1945 China, France, Great Britain, the then Soviet Union, and the United States were given a veto power, and nobody else was. Quite frankly, for all sorts of reasons, that distribution of power in the Security Council is indefensible in 2006. And if you believe in the survival of the United Nations, as I do, then one of the items on the agenda is creating a Security Council suitable to the world of 2006, or now 2007, and not the immediate post-World War II reality of 1945. Ditto with regard to the Constitution. This book is not an attack on the framers. It is not an attack on their beliefs that certain compromises were necessary in order to get the Constitution started. One of these compromises obviously was slavery. And I take it that nobody would argue today that because collaboration with slavery was necessary to get a Constitution in the first place, therefore it should be adhered to ad infinitum. Ditto with the Senate. Are you comfortable with an Electoral College that regularly sends to the White House people who do not get a majority of the vote? Since World War II alone, this includes Harry Truman, John Kennedy, Richard Nixon in 1968, Bill Clinton in both of his elections, and very notably George W. Bush in 2000. Bush exemplifies a different issue, which is that you can get to the White House even without coming in first. But coming in first may not be enough to justify being in the White House if we genuinely believe that the president should be the person most likely to represent the majority of the public. Other countries have runoff systems. My own favorite would simply be an alternative transferable vote, whereby you would rank order your preferences and they would be distributed accordingly, which assures that the winner is the most likely to have a plausible claim to represent the majority. But it seems to me that the Electoral College is subject to all sorts of criticisms. I've mentioned the most obvious one. Another dreadful feature of the Electoral College is its emphasis on battleground states as an electoral strategy, so that my wife and I, who share a time between Massachusetts and Texas, in some real way didn't know, or if we hadn't read the New York Times, we would not have known that there was a presidential election going on in either 2000 or 2004, because neither of the candidates, for obvious reasons, saw fit to spend any money on advertising or even show up to give any speeches during either of those two monumental campaigns. But it's not only that we didn't have the benefit of hearing from the candidates. It's also the case that the largest states in the country, the states with the largest cities, tend to be safe states. My own state of Texas has 3 of the 10 largest cities in the United States. California is obvious, New York is obvious, Illinois is obvious. None of these states was in play in either 2000 or 2004. This, among other things, helps to explain why neither candidate has given cogent speeches in some years about what national policy should be vis-a-vis our largest cities. They really have no incentive to do so. Instead, you have idiotic presidential campaigns over prescription drugs for the elderly, maintaining the boycott against Cuba, and maintaining firm support for the government of Israel, which was the motif of the 2000 campaign as it all boiled down to Florida. In 2004, you would have thought that the fate of steelworkers in Ohio, and I'm sympathetic incidentally, with the fate of steelworkers in Ohio, but it's kind of lunatic to believe that that was the most important issue facing the country in 2004, but a content analysis of presidential addresses and advertising might lead a rational person to say, well, Americans generally must really be concerned about the fate of steelworkers in Ohio, much more concerned, for example, than the fate of America's largest cities. And it seems to me that this is beyond certain formal deficiencies of the Electoral College, the benefit given small states. George Bush got 9 electoral votes by carrying the 2 Dakotas and Wyoming. Al Gore got 5 electoral votes for carrying New Mexico, even though Mexico has a larger population than the total population of the 2 Dakotas and Wyoming. That's a formal defect, but the way political campaigns are shaped around the Electoral College is an informal defect. In any case, we'd be better off without the Electoral College. One of the things I did not adequately focus on, at least in my initial introduction to the book, what I wrote is, are you concerned that the president might have too much power, whether to spy on Americans without any congressional or judicial authorization, or to frustrate the will of a majority of both houses of Congress by vetoing legislation with which he disagrees on political grounds? I think those are grounds for concern. The most surprising feature of the book, for me, insofar as something I really hadn't thought much about before writing it, and then have come out with quite strong views after it, is that I think there's no real defense for the presidential veto on policy grounds. I think it's quite easy to defend a presidential veto made on constitutional grounds. After all, the president takes an oath of office to support, protect, and defend the Constitution of the United States, and one can make an easy argument that signing legislation that the president believes is unconstitutional is a violation of the oath. This does not remotely defend the power of the president to veto legislation simply on policy grounds, so that, in effect, we have a tricameral rather than a bicameral system. And it's the bicameral system consists of 435 representatives, 100 senators. Even if I don't like the allocation of power in the Senate, I can imagine a Senate of 100 senators that I would warmly support, and then one president. And so the one stroke of a pen can disable the will of a congressional majority. One of the problems I have with some of my colleagues in the legal academy is that we and they spent an inordinate amount of time talking about the counter-majoritarian difficulty, or the so-called counter-majoritarian difficulty of judicial review. In our entire history, the Supreme Court has invalidated 165 pieces of federal legislation, most of them of no great importance, whereas the president over our history has vetoed 2,501 bills, many of them of significant importance, 95% of which have been upheld. Only the president of Cyprus has a higher rate, and that's because under the Cyprus Constitution, there is an absolute power of veto. But it's not only the ability of the president to stifle legislation passed by Congress, but the president also obviously has a far greater role during the run-up to legislation than, say, the Supreme Court has with regard to fears that the court might later invalidate federal legislation. Indeed, the disgraceful behavior of Congress in passing the Military Commissions Act, where Arlen Specter, for example, the former chair, I'm glad to say, of the Senate Judiciary Committee said, well, this bill is probably unconstitutional, but it's really important that we pass it, and I hope the Supreme Court will strike down the unconstitutional sections. That's a very, very different mode of behavior from calculations made by senators and representatives as to what they're going to vote for with regard to legislation that will be vetoed. But what I left out and wish that I had focused more on with regard to the presidency is that, are you satisfied with a political system that means that we are stuck with incompetence, or persons, this is probably a less sympathetic reference among members of the American Constitution Society, but one has to take seriously the possibility that Bill Clinton disgraced his office for very different reasons than Bill Clinton, than George Bush. But in either case, is there any real merit in the 21st century to a fixed-term presidency that doesn't have the possibility of a vote of no confidence? It seems to me that in most political systems around the world, George W. Bush would be out of office, to be replaced, to be sure, prior to another election by another Republican. But it would be a Republican, presumably, in which at least the Republican Party, and one might go beyond that to say the country at large, had more faith in than George W. Bush. If we had a system like that in the United Kingdom, for example, I think we would see something similar to Margaret Thatcher's. Probably the most important peacetime prime minister in the history of the United Kingdom, being bounced unceremoniously in 1990 when her party came to the conclusion that she was no longer the person to lead them into the next election. She had gone over the top with regard to certain policies. She was out, John Major was in, and John Major, in fact, did win the next election. And Tony Blair is being pushed out, albeit kicking and screaming, by the Labour Party. We don't have that possibility. I think this has all sorts of consequences, somewhat similar to the consequences of Article 5 with regard to cognitive dissonance. If we can't get rid of the person, then there is a tendency to believe, well, maybe he's not that bad after all, because it really would be too terrifying to say that we really are stuck with a raving incompetent. I think we do have a raving incompetent. And I do think because of our Constitution, we are stuck with him until 2009. And one simply has to hope that he doesn't take us further down the road to disaster. Presumably we'll find out more this evening. But as I say, it seems to me that this is a huge defect of the 1787 Constitution, even if it made perfectly good sense in 1787. There's also, incidentally, the veneration aspect. In a perfect Constitution, the head of the government would not also be the head of state. That the president gets an additional boost, not only from the fact that you can't get rid of him, or in the future her, until the end of a term, but also because of hail to the chief. I'm not a monarchist, but one preferred feature of the British system is that you sing God Save the Queen. When you see the Queen, you don't sing God Save the Prime Minister. And it seems to me we would be better off if we did split head of government from head of state. Does one really want justices on the Supreme Court to serve up to 4 decades and, among other things, to be able to time their resignation to mesh with their own political preferences as to their successors? That may be a less shocking proposition at Duke than at other law schools, because Paul Carrington, together with Roger Crampton, has led the way in offering both serious criticism and a proposal to get rid of life tenure on the Supreme Court. I don't think life tenure on the Supreme Court is the most serious problem we face. I think the others are distinctly more serious, but if we were to open up the question of what parts of our Constitution in the 21st century survive what Alexander Hamilton in the first Federalist paper called reflection and choice, I don't think life tenure would survive either. And then finally, as I've already suggested, do you support Article 5 and the practical impossibility of amending the Constitution? I said at the outset that this book is primarily directed to my fellow citizens, and the argument that we really do have a defective Constitution, we ought to be able to do something about it, and what would the mechanism of doing something about it would be calling on Congress to call a new constitutional convention that would really look at this. But I do want to focus on one subtext of the book that may be directed more to my fellow academics than the other part of the book. It's subtextual rather than a main part of the text, but but whenever I'm at law schools, I like to bring it to the fore, and that is that I think that we who teach constitutional law seriously disserve our students, and I speak as a sinner and not only somebody who, but now I call on, I've repented and I call on others as well. That is to say, the standard form constitutional law course focuses only on constitutional controversies. Generally speaking, they focus only on cases in courts. Over the last 10 years, there has been a movement to look at the Constitution outside of courts. There are many of us, for example, who think the Office of Legal Counsel in the Justice Department is every bit as important as any federal court. Particularly, Chris mentioned, I was interested in the issue of torture. The OLC is far, far more important than any Article III court. But the point is that all of these inquiries still focus on what is litigated or what is controversial. We spend very, very little time in our courses on what I call the Hardwired Constitution, which is really what I'm putting forth to you today. And as I say, even though I've now changed my own behavior, I haven't changed it all that much. In my 42 or 45-hour course, I take 1 hour to explain to students what I think are the truly most important parts of the Constitution, which are the hardwired parts that I've been describing. That is, in terms of understanding American politics for good and for ill. I think that the hardwired structures are more important than the Bill of Rights, are more important than the 14th Amendment, and so on and so forth. But then after making this argument, I go on for the rest of the semester to teach about Article I, Section 8, the 14th Amendment, the Bill of Rights, and the like, because that's what I've been trained to do. And insofar as one of your roles is to learn how to be a practicing lawyer, then to learn how to be a practicing lawyer does indeed require becoming familiar with the live controversies of American constitutional law. But one of the other functions of a course in constitutional law, and quite frankly, I believe the principal function, even if not necessarily purpose, of a course in constitutional law is a citizenship function. As an empirical matter, most lawyers never have cases involving constitutional law. If we really were trying to prepare you for the kinds of legal practice that statistically you're most likely to engage in, then constitutional law would come well down the list. The reason to require constitutional law, and my university, the University of Texas, requires 7 hours of constitutional law. The reason to require constitutional law has much more to do with citizenship than it has to do with preparing you for a future career as a constitutional lawyer. For better and for worse, as people from Tocqueville on have pointed out, lawyers play an inordinate role of civic leadership. And one of these roles ought to be to engage in cogent discussion of what is good and what is problematic about the Constitution. It is lawyers who tend to be invited to give Constitution Day talks. It is lawyers who are invited to give Law Day talks. A lot of lawyers go in and say, well, really the great thing about our Constitution is the Bill of Rights. And Bill of Rights is a great part of the Constitution. But I wish that more lawyers went into these sorts of ceremonial occasions and said, the Bill of Rights might be great, but you ought to be aware that more important than the Bill of Rights in terms of understanding the role the Constitution plays in our political order is the president's veto power, is a lot of dull and boring issues, or what you think of as dull and boring issues from high school civics courses, the kind of stuff that you might have learned at one point, like how a bill becomes a law and stuff like that. But it's not really sexy. It's not very engaging to most people. It does, unfortunately, tend to be far more important than the kinds of issues that do tend to engage both those of us who teach constitutional law and those of you who take constitutional law. I am not suggesting getting rid of inquiries into constitutional interpretation, of classes on the First Amendment, 14th Amendment, et cetera, but it does seem to me long overdue that we rebalance our portfolio with regard to the amount of time that we spend on the issues that are open to interpretation, as it were, and the hardwired parts that, except in the most postmodernist of seminars, are not really open to interpretation. They constitute our political system in a very profound way that we almost never think about, and we ought to spend much more time thinking about them than we do. I am very, very eager to hear your questions, challenges, whatever. Yeah.
I think you're right about a lot of the problems with the Constitution, but I worry if we held a new constitutional convention, we'd end up with a net worse outcome, that a lot of the protections we take for granted, like the right to privacy, that aren't specifically in the Constitution, would be done away with. As close as we've come to passing constitutional amendments on flag burning and gay marriage, it would seem that in an easier system like a constitutional convention, those would be shoo-ins. And so would we really want the outcome to begin with? And then two, doesn't the status quo really solve, because the Supreme Court has been able to kind of make amendments through interpretation in changing things like the right to privacy?
Yep. Great question, and not surprisingly something I've been asked before, and to which I hope that I have answers. First of all, with your very last point, the Supreme Court, for better and worse, has done a lot of informal constitutional amendment over the years. For worse with regard to freedom of contract, for better for many of us in this room with regard to privacy, new and surprising interpretations of the Equal Protection Clause, and stuff like that. The Supreme Court has done nothing and will, except in a science fiction universe, do nothing about the patent violation of one person, one vote in the Senate, the fact that we can't get rid of an incompetent president. And as I just go through the litany of hardwired, one of the things it means to be hardwired is that we don't imagine litigating these things. And one of the reasons we don't imagine litigating these things is that we can't imagine a Rule 11 motion for sanctions if you actually go into a court and say that you, the court, ought to rule the Senate of the United States unconstitutional. The court was willing to rule the Senates of the 50 states unconstitutional in Reynolds versus Sims. But I think not even the Warren Court would have been open to a suit against the Senate and some of the other features that I talk about. Now, with regard to the runaway convention, I have two different sorts of answers. One of them is that if a convention, and remember, although in a science fiction world I would wave a wand and call the convention tomorrow, in a more realistic world, I don't want to necessarily say they're more realistic fantasies, except as against waving a magic wand, but the more operative fantasy is that people will in fact agree that the Constitution really is a danger in certain ways. They will talk to their friends. Over a number of years, there will be a serious political movement, so that we're talking about a constitutional convention when? 2012, 2014, 2016. But we're never going to have a constitutional convention at any time short of the post-train wreck convention. But we're never going to have a constitutional convention otherwise unless there is a genuine mass movement for it. Now, if the delegates to such a convention would represent single-issue groups. And you can fill in the blank with both your favorite and your unfavorite single-issue groups. Then the likely consequence would be gridlock and nothing would happen. As I argue in the book, the current Constitution is the default rule. So it's not that a new convention would tear up the Constitution and we'd be in some Lockean state of nature. We would have this Constitution unless and until a proposed replacement was ratified by we the people. Now, if a convention is captured by single-issue groups, it's not going to be ratified. One of the things you discover in state constitutional conventions is that they often go down because of the zeal of a particular single interest group to write its favorite policy into the Constitution, and then states almost always require proper ratification. You can't get a majority for it. So that's why I'm not really fearful of the runaway convention that either requires school prayer or bans any mention of God under any circumstances, that either confiscates all guns or requires all of us to have guns and to know how to shoot them. And you can just go through the litany of single issue sorts of controversies. Now, with regard to the hardwired Constitution, I think this is the perfect time to have a national discussion. I think for the very simple reason that we're in a very real way behind a Rawlsian veil of ignorance right now. We don't know who's going to be president in 2009. We don't know who's going to control Congress. So even if you're motivated by partisan juices, it's not clear what your partisan juices would tell you about whether the president should have a policy veto power in 2010 or 2012. If you're a Republican and envision Hillary Clinton as president, then you might say, let's get rid of the veto power. If you're a Democrat and envision Rudolph Giuliani or John McCain as president, then you also might not be so fond of a veto power. You can march through all of these issues, and to a surprising degree, they're not partisan. And it's not that they're nonpartisan because there aren't significant political ramifications with regard, say, to whether the president has a veto power. But when you really don't know who the president is going to be, what party the president will represent, you're kind of forced to think in more public interest terms because ordinary partisanship becomes almost irrelevant. Now, the task is to generate a serious discussion of what I keep calling the hardwired Constitution without getting distracted by discussions of affirmative action, abortion, etc., the Pledge of Allegiance, that tend to dominate the discussions of such constitutional amendments as are proposed. It may be very, very difficult to do that. And one last point. If one is fearful of a constitutional convention because one really doesn't trust one's fellow citizens to come up with acceptable results, then I think this raises very serious questions about whether we really believe all that much in democracy. I think this is important in part not only with regard to the way we describe ourselves to ourselves, that is our own system of government, but it is the stated view of the United States right now. The 2006 mission statement of the United States is to promote democracy around the world. That's obviously one of the issues underlying Iraq. Well, what does democracy mean? There is no serious conversation occurring in this country as to what we mean by democracy and whether our notion of democracy, which I argue is a quite limited notion in a number of important ways, is what we mean to be selling around the world, or whether by democracy we mean in the 21st century something considerably more majoritarian than we have. But it does seem to me this is another very, very serious issue that is generated by especially the suspicions of a constitutional convention. Yeah.
Yeah, I mean, what you just said, I think our notion of democracy and our notion of political parties and what it means to be a Republican or a Democrat is shaped by how individuals interpret the Constitution. So I'm just wondering if your idea of amending the Constitution, it seems like, well, England maybe has the Queen or the King and sings God Save the Queen. That has to go to the national fabric of a British identity, whereas the Constitution goes to our identity as Americans. And it just seems to me if you're going to radically change the Constitution, you're going to give the whole country a really big identity crisis.
That could happen. But, I mean, I would say that the part of the Constitution that ought properly to constitute us as Americans is the Preamble. I think we have a great Preamble. I have no problems with a Preamble. I think the Preamble, and incidentally, I think it is a significant statement about legal consciousness that the Preamble plays a very minor role in our discussions of the Constitution generally. It's rarely taught in constitutional law courses, and it's rarely taught in part because it rarely becomes the basis of litigation. But the Preamble sets out the point of the constitutional enterprise. Everything following the Preamble is merely instrumental to whether or not it will allow us to achieve the really admirable and inspiring goals of the Preamble. And my argument, obviously, is that in significant ways, what comes below the Preamble is significantly dysfunctional with regard to achieving the goals of establishing justice, the blessings of liberty, and all of the other things that really are worth venerating. So this would be part of the conversation, that have we historically viewed ourselves as constituted by precisely the 1787 Constitution? The answer is obviously not, because even though I think we have had insufficient amendment of the Constitution, we have, after all, had some amendment, and incidentally, it is the case with regard to those amendments that are relatively important, that their opponents always adopted as one of their tropes that this is the end of our constitutional system as we knew it. This argument was made with slavery. This argument was made with the 14th Amendment. This argument was made with the 15th and 19th Amendments on black and women's suffrage, respectively. So it seems to me that that one can be constituted by the Constitution without saying, well, that means the Electoral College, or that means that Wyoming continues to have the same number of votes as California. Now, you might regard this as a much too minimalist notion of the Constitution, but it's my notion of what it means to be constituted. And the first book I wrote was titled Constitutional Faith. And I continue to have some very real faith in the Preamble. And what has generated, I suppose, what could be described as my anger with regard to much of the rest of the Constitution is that I think that it serves as a barrier rather than a genuine means of achieving what is really most admirable in our constitutional order. Don.
Andy, I've been reading the Federalist these days by sheer coincidence. It wasn't in preparation for your talk. But it seems to me there's, in the talk, I'm not sure about the book since I haven't read it, there's a missing element, and that is the elevation of majoritarian democracy above other values is very much at odds with the Federalists. It seems to me you have to come to grips with the other values that they were trying to support. I mean, for example, the the Federalist was decidedly opposed to majoritarian democracy in its more extreme forms, precisely because majorities they understood were inclined to undemocratic behavior in other ways. You also, it bears notice that the First Amendment is a very highly undemocratic feature of the Constitution, but you're not against the First Amendment. So I think you have to pick and choose the way to defend this. I have two other quick comments. Federalism, and the upper house. I'm curious to know how you would constitute the upper house on strictly population grounds. Most upper houses around the world are actually not dedicated to Federalist values. They are chosen to recognize a nobility, an aristocracy, or notable people in the population. Those that are concerned with federalism are almost invariably composed by territory and not by population. Third point, I'm a big fan of the alternative vote, but bear in mind that the person who comes out second or third even in first preferences could end up the winner under the alternative vote. So you might be left with the same predicament that the Electoral College gives you.
Going in order, not surprisingly, I don't view myself as an extreme majoritarian. I'm, an American constitutional Democrat, little d, little c, which means that I would in fact want to place certain barriers on unrestricted majority rule. Two quick things about the Bill of Rights. I think the Bill of Rights are a good thing. I also believe that they are so subject to interpretation that by and large they have served much more as what James Madison himself called parchment barriers than as strong explanations for what degree of protection we're really willing to give at any particular time to the constitutional values presumably instantiated in the Bill of Rights. But I said in my opening remarks that I'm not a fan of a single house parliamentary system, for example, because I think that is too much majority rule and you don't get some of the proper ways of clipping unrestrained majority rule, as you do with bicameralism, for example. So that's with regard to your first point. With regard to your second point, I resist the description of the Senate as having anything to do with federalism in any very strong sense. The current Senate, I think, is best described as an affirmative action program for the residents of small states. Federalism has to do either with structuring a system so as to promote diversity, the Brandeisian little laboratories of experimentation, or some principle of what Europeans call subsidiarity, so that you really assure that decisions are made by the smallest level of government possible, in part to promote certain values of civic republicanism, that it's easier for people to participate in smaller units of governance than larger. Now, for better and for worse, since the so-called progressive amendments, the 16th and 17th Amendments taken in tandem, the 16th Amendment, the income tax amendment that really allows the development of the modern tax and spend state, and the 17th Amendment, which is the final liberation of members of the Senate from their state legislatures. There's no incentive for members of the Senate, any more than members of the House, to be particularly concerned with safeguarding the strength of federal institutions. If one is truly committed to supporting federalism, and I confess that I'm somewhat of an agnostic. on federalism. I think federalism has its attractions and its problems. One of the virtues of a convention for me would be to hear really serious conversations about how much we want to promote structural federalism. But the German Constitution is the one to follow. The Bundesrat is constituted by state officialdom. And not surprisingly, you get a lot more attentiveness to preserving the autonomy of state governments than you do in the United States. This is why Steve Breyer, for example, was simply misleading in his debate with Scalia in the Prince case, even though I'm more sympathetic with Breyer than Scalia. Scalia says, in essence, you should never look abroad. Breyer says, oh yes, you really should look abroad for useful information. He says, look, the Europeans and Germans often use state officials to implement national policies. Well, it actually would have been helpful if Justice Breyer had also informed us that perhaps one reason that the German national government is given the power to what Sandra Day O'Connor would call conscript or kidnap state officials to enforce national policy is because state officials, in effect, have a veto, given the way the Bundesrat is constituted. That just doesn't describe our particular system. So it seems to me that that no serious defender of old-fashioned federalism, I think, for example, of Michael Greve at the American Enterprise Institute. He and I were together at Boston College several weeks ago, and Michael quickly agreed. He lamented much more than I do. I'm a New Dealer. But we both agreed that the Constitution we have, in no serious sense, constitutes a defense of strong federalism. Article 1, Section 8, the mantra, limited government of assigned powers, also turned out to be a parchment barrier with regard to the shift of power from states to the national level of government. The final point on the Electoral College, you and I would certainly agree, and Don and I first met over 4 decades ago when we were graduate students together. There is no perfect system of designing an election process. The alternative transferable vote isn't it, but as is often said with democracy, et cetera, I suspect that the alternative transferable vote has fewer imperfections than the way we select presidents now, but it's always going to be the case that you're going to be making trade-offs. And it is truly utopian to believe that there is a template that would provide just the right answer to every question that one might have. Yeah?
I have questions about some of the more detailed aspects of your argument. One was, you sort of suggested that the presidential veto there's no good policy reason for the policy veto. I was wondering if in a situation where Senate and House are both not really one person, one vote type of situations, whether you could argue that the presidential veto actually might pull that back a little bit so that we institute only policies which would result in that. And then my second question regarding the set terms is you seem to suggest
regarding
the set terms, term limits, that you would let it still be, say, a Republican candidate through 2009.
Yeah.
Isn't that sort of just a cop-out for the end result, which really should be, if we're really going to make it democratic, it should just be a whole new vote? Okay,
well, the last point is kind of easier. If there is a genuine vote of no confidence, then you can call new elections. Or, as happened in the UK, the no confidence in effect can be a vote by the party in power, and it preserves power. The argument I would make is that there ought never be a change of party in the White House without intervening elections. So there would be at least these two different tracks. With regard to your first point, one argument that is often made with regard to the veto is that the president is the tribune of the people. The president is, it's often said, is the one person in our national system who is not irredeemably localist. And it does seem to me that one problem with both the House and the Senate is that every single member of the House and the Senate is a local official. The Senate obviously represents a larger territory, except in the one representative states. But still, the senator from North Carolina has a maximal incentive to think about North Carolina and not to think about some inchoate national interest. Now, going back to Don's question, it does seem to me desirable if one is given free rein on redesigning a Senate to include some basis of territorial representation, but it also would seem to me desirable to inject into a Senate more national representatives as well. Now let's turn to the president for a moment. Is the president truly a national leader? And my argument would be no, for a variety of different reasons, putting to one side the fact, and again picking up on Don's point that he was rereading the Federalist, one of the things that's simply true about particularly James Madison is that he hated the very idea of a party system, at least in 1787, and that the arguments for how the United States would operate, including the checks and balances, et cetera, really don't map on very well to a modern party system. But put to one side the fact that the president is the head of a party as well as the detached head of the country. There is the problem that the president may not be, in fact, the majority's choice. So it seems to me, for all of my dislike of the Senate, I am still willing to say that any bill that can get the joint approval of the House and the Senate together, the vector sum of all of these different locally elected people, is at least as likely to be in some inchoate public interest as the view of a single person president or even the institution of the presidency. And this is especially true if the president doesn't even truly have the support of a majority of the country, either at the time he or she was elected or in terms of any kind of popular approval thereafter. The second problem is linked to what I've already said in my critique of the Electoral College, that is the informal weakness of the Electoral College, that presidents as head of parties who are concerned with being reelected have a tremendous incentive to look at public policy not from a national perspective, but from a battleground state perspective. Thus, you have what any free marketeer, including the editorial page of the Wall Street Journal, correctly described as the shameless pandering to Ohio with regard to tariffs on imported steel by George Bush, because Karl Rove had told him altogether accurately that it was in his interest to make public policy by thinking primarily of what is good for Ohio rather than what is good for some detached notion of the American economy in general. So these are quite different reasons why I'm really not taken with the notion that we can trust the president to be the voice of some sort of national interest against the parochialism of Congress. I believe that the president as a single person is far more likely to be less parochial than any given member of Congress for obvious incentive reasons. I don't think that translates into the proposition that the president will be less parochial than the collective House of Representatives or the collective Senate, and especially when you aggregate those institutions together. All sorts of problems with the House and Senate. Partisan gerrymandering in the House, the allocation of votes in the Senate, but I still am willing to say that Congress has its strengths as well as its weaknesses with regard to representing we the people.
I'm going to stop there. I want to join me in thanking Zanny.